Please be seated. Court now calls case number CV140399, Langendorf versus Buckeye Water. This is the time set for oral argument. Counsel, as you are probably aware, these proceedings are being audio and video recorded. A link to these proceedings will be available on the court's website within a few days, so we want you to be aware of that. Please identify yourself and your client when you step up to make your argument. Each side has 20 minutes. And counsel for the appellant, you may set aside some time for rebuttal. As you also are probably well aware, we have read all your briefs. We're very familiar with the record, and we have discussed the case in conference. Keep track of the time with the podium in front of you. And is it Mr. Udall?
That's correct.
All right, you may proceed.
Your Honors, the plaintiffs have identified the procedural error in the district's motion for summary judgment. That motion was a one-issue presentation, and I'll quote from their actual pleading in the motion itself. It states, as its only cause of action, the district engaged in the exercise of an administrative function involving the determination of fundamental governmental policy under ARS 12-820.01A2 when it implemented its shotcreting process to protect its canal from erosion. Nowhere in this motion was there any addressing of negligence issues. Similarly, in the district statement of facts, there were no allegations made regarding any aspect of the district performing according to an appropriate standard of care. No negligence issues of any kind were raised.
If they claim absolute immunity, doesn't that, even if they negligently performed or violated some sort of standard of care for the water conservation and drainage district, don't they get then the waiver?
Well, the Cole case, Judge Portney, the Cole case distinguishes between the actual implementation, the creation of a program that would be a basis for invoking absolute immunity, and then the carrying out of that. There can still be negligence in the carrying out process, but if done properly, as the court determined, the Supreme Court determined in the Cole case, there can be absolute immunity, and I will discuss momentarily what I believe might have been the appropriate action for them. I don't know that they could have done it. But for a response to the motion for summary judgment, it was not incumbent upon the plaintiffs to address negligence issues when the only issue presented by the district was the claim for immunity based on a shotcreting program. Now, the shotcreting program is where they would apply a concrete type material that, upon hardening, would preserve the canal walls. If the district had presented any evidence in the form of an affidavit where the affiant opined that the only way to solve the gopher infestation problem was to shotcrete, then the plaintiffs would have had an obligation to respond to that. Plaintiffs also presented additional facts in opposition to the motion for summary judgment. The plaintiffs also demonstrated with the district's own statements the shortcomings of the district's evidence for its one-issue motion. They referenced the deposition of the district's manager, and they referenced disclosure statements and referred to industry material on the ease of controlling gopher populations. Importantly,
So you're making a distinction between the district's decision to do this and then the district's implementation of its plan in terms, they get a free pass on doing it, but how they do it was negligently performed, so they shouldn't have absolute immunity.
Judge Portly, they only get a free pass if they do it right. In the Cole case,
Okay.
it was the model. The model was they had experts determine the need. They first determined they had a problem because busy intersections created problems for pedestrians and children on bicycles. They further determined that they had a scarcity of resources to deal with this problem. Therefore, they came up with a plan to address the issue, and they came up with a sophisticated computer program which helped them to determine which intersections had the greatest need for being fixed, if I could use that word. We don't have that here. We have a situation where there was some discussion in the board meetings of shotcreting for the purpose of fixing an erosion problem. The erosion problem was created by large amounts of water flowing through the canals. Nowhere in their material does it indicate that the shotcreting process was for the gopher infestation issue.
Counsel, the affidavit from the city official states that. Did you present a contrary affidavit to that, the city official's affidavit? It states it.
When you say the city, you're referring to the
Or the
Judge
district,
Gould.
I'm sorry, the district, he states it. I can't recall the name of the individual, but it's in his affidavit directly, that it was to cover erosion from water and gophers.
That affidavit, there were two affidavits, if I could point that out, Judge Gould. There was the initial affidavit that was attached to the statement of facts for the motion itself. I don't believe it was there. I believe he stated in the reply, there's a very brief affidavit in which he states that this is the first time we learn of it. It wasn't in the motion itself. It was his mere statement that it addressed that also.
Did you contradict that statement with another affidavit that said that's not so?
I did not, Your Honor.
Then why would we not presume that statement to be accurate? What's the evidence that contradicts the affidavit of the district's, I forgot his name, but the official who states it was to cover erosion and the rodent infestation?
Judge Gould, the evidence is considerable in what was presented by the district itself in its motion for summary judgment, in its statement of facts. All the information that was presented dealt with erosion because of water. There was nowhere in that where they identified there was any statement dealing with that.
Right. I understand what you're saying. The documents that were attached to the affidavit, the minutes and so forth, I understand your argument is that it doesn't expressly state anything other than water erosion. Is that what you're referencing?
That's correct.
But there's also the statement in the affidavit that says it was directed at water erosion and rodent infestation. And what I'm asking you is, when a party comes forward with a motion for summary judgment and they have an affidavit, they have the statements in the affidavit, they also have some supporting exhibits and records and so forth, and there's a statement directly in the affidavit that says the district adopted this policy to deal with water erosion and rodent infestation. And you don't contradict that avowal in the affidavit with your own affidavit. Isn't the trial court correct in concluding that the policy was adopted to deal with both? It almost seems like, counsel, the district comes forward with their absolute immunity defense, and they say, between the affidavit and the supporting documents, here is the fundamental governmental policy we're going to adopt to deal with water erosion and rodent infestation, according to the affidavit of the government official. And then you respond with, well, but you're negligent in the way you did it. And that wasn't a good policy because you should have sent people out to kill the gophers and the rodents. But you're not addressing the defense that they put forward. You're not contesting that, in fact, they adopted a fundamental governmental policy to deal with water erosion and rodent infestation on the canals by using a shotcreting program. And I looked and I tried to see where you contested that, but you move around it with, well, it's not a good way to do it. And we have an expert that says shotcreting doesn't work. But where do you take head on and contradict that this was an exercise of a fundamental governmental policy by the district?
Judge Gould, we do not dispute that there was an attempt to engage in the creation of.
Counsel, I have to question you on that. What do you mean an attempt? They did adopt a policy. This is the policy they adopted. They did have a discussion about how to address the problem with the canals, and they set up a matrix just like in coal, and they tried to identify what were the highest risk areas of the canal, and they prioritized them, and they started shotcreting in the areas that they had prioritized. I can't see the distinction from coal in what you've presented. I understand your argument to be shotcreting's a bad idea. We have an expert that we came in with after the fact that says you shouldn't use shotcreting. You need to send out exterminators out there to kill these gophers. I understand all those arguments. You could be right about that, but I mean, we've set aside in our Constitution these immunity defenses. They developed this policy. They allocate their resources to address the problem in this fashion. And they, in fact, did that. What's the evidence contesting that they considered it, they weighed the options, and they implemented that policy to deal with erosion on the canals?
Judge Gould, I cannot dispute that occurred, but there are other elements of coal that were not complied with. For example, they, in their own material, indicate it was an experiment, a test. It was not to deal with an overall problem. They were dealing with it on a very minute and in a very small way. That's one problem we've pointed out. The other problem was they unwittingly acknowledged in their reply that they were addressing the gopher issue, thereby taking it out of the scope of coal, because in essence they were saying, we can deal, in addition to this program we created that looks like the facts of coal, we also are dealing with the problem. Well, if you're dealing with the problem, you don't have a scarcity of resources, and you don't have a situation that comes under coal. So they're saying, we can fix it, we can deal with this problem. We walked up and down the canals, we looked, and what they finally admitted was they only looked for seepage. And so by having a program that had in its, not just the implementation, the program itself was not designed to deal with the issue overall. It was nothing more than an experiment. And the way the
issue about seepage was how you identify, how you prioritize areas of the canal for shotcreting. But that wasn't the only factor they looked at. In their matrix they had all kinds of factors they looked at. Their lining matrix looked at areas. It's right in the matrix. I looked at it. It talks about areas where there's been problems with rodents, native grade to high water mark, known history of leaks, and gopher holes. That's right in the lining matrix. Ongoing canal width erosion, road width, other special risk factors. They look at all kinds of things to decide how to allocate their resources and how to deal with this problem. I'm not suggesting to you that it was a good idea. I don't really know whether shotcreting works or not, but isn't this the very thing that we provide immunity for governmental entities if they exercise this kind of discretion?
Judge Gould, you're correct that the statute provides that, but how our fact pattern differs is it was not intended to be an ongoing program. Their own material indicates it was a test. They worked on two of 32 segments of the canal, they acknowledge in their reply, or state in their reply, that they're working on it on an ongoing basis, that they are maintaining the canals and that they continue to look for gopher infestation. So we believe that in essence takes us out of the coverage of coal, because if they're saying we can do this by just going up and down the canal looking for gopher holes, looking for seepage, in essence what they're saying is they don't have a problem that can only be addressed by applying scarce resources. They're saying we do this on a daily basis. So we don't meet that requirement of coal that there be an allocation of scarce resources. So I would respectfully submit, Judge Gould, that they haven't brought themselves under the coal pattern, and so we've indicated a number of reasons why they don't fit under the coal pattern. So in the oral argument, the counsel suggested that we had a duty to present affidavits. There was no affidavits of theirs to which we had to respond. The case of Maxwell versus Fidelity Financial Services, 184, Arizona 82, states an opposing party can respond by memorandum, but the memorandum must reference depositions, answers to interrogatories, or admissions to comply with the rule. We did. So we, in essence, objected to their allegations. We created issues of fact, and we had an affidavit that stated that there is ease in resolving the gopher issue. This was Mr. Langendorf, who has lived there for many years, who was able to deal with it. What we believe is categorically wrong with this, with the district's position, is that it first comes in and says we have a situation that brings us under the coal case, and we think we meet all the requirements. And then in their reply, they state, oh, by the way, we're also addressing the gopher issue. We're maintaining the premises, the canals. And by doing that, we believe that they've taken themselves outside of that. We believe that we created issues of fact regarding the allegations that they come under coal, that they have, that they are entitled to a immunity, to the absolute immunity statute, when they're only dealing with a program that they admit was just a test. It wasn't like coal, where there was an intent to deal eventually with all of the dangerous intersections. Here they just have a test. The test is to deal with where they have the highest amount of erosion from high water flow, and that's because they are wheeling water to other districts. I'm going to reserve the rest of my time. Thank you very much.
Thank you, counsel. Mr. Herzog?
Thank you, Your Honor. I am Michael Herzog from the Herzog Law Firm, and I'm here representing Appalachia Buckeye Water Conservation and Drainage District. I don't think there's really any question when you look at the evidence that was provided to the court. We have affidavits from Ed Garrick, who is the gentleman to whom you referred from the district, talking about the fact that there was a program put into place, there was a matrix done to show what areas were the most vulnerable to both erosion and gopher infestation. And in addition to that, if it was unclear from the matrix, we provided in the reply, in the reply statement of facts, we provided the affidavit from Mr. Garrick, which specifically mentions that it is part of the program was to stop gopher infestation. I don't think there's any question under Cole that the decision about what money to allocate to this program is clearly one of governmental discretion that's subject to the absolute immunity in the statute. And there's really no argument that was presented, as far as I can tell, that this does not, that it's not that the application of governmental funds is not something that falls within the statute. The problem that
plaintiff has to some extent with regard to trying to distinguish coal, as far as we see it anyway, is that here they come in their appellate brief and they say, oh, well, we didn't implement the program well. That our program wasn't a good program. But what evidence was there of that in their response to the motion for summary judgment? In fact, what evidence is there of that today, to tell you the truth, that the shotcreting program was done inappropriately? None.
But I thought that the argument that the program wasn't implemented properly still amounts to an assertion that it didn't invoke the right priorities.
But there has to be evidence that there's somehow.
But even if there was evidence, isn't Cole say, we in the Court of Appeals don't get to sit here and evaluate how the district prioritized the expenditure of public funds?
That's correct. I mean, that is why, in fact, of course, there's an absolute immunity, because if you're going to look at the manner in which it's done, and say we don't agree with that, of course, then you wouldn't have an absolute immunity.
Well,
that would be.
I mean, that's the only way I can understand this argument about consideration of the gopher issue. It's a disagreement as to the factors that the district employed in prioritizing, and I thought that's what Cole protects.
I agree, Your Honor. I do agree with that. And the other argument about
To the fact that your Zanjeros walk around and if they see an infestation, something may get done in spite of the matrix.
yes.
I think the argument is that takes it out of coal. I'm still weighing that, but I just see that as recognizing, like an intersection, that some places you may have to do something sooner than you would otherwise based upon what you find on the ground.
Right. I mean, that goes into the prioritization. You look at it and you say, okay, just as Judge Gould pointed out.
In coal, they put in some signals at some intersections that it didn't follow the priority. In addition to following their priorities, they went in and put in some lights at some intersections that didn't follow the priority, and our Supreme Court said that doesn't take away the absolute immunity.
Correct. And once again, it's one of the factors that they consider when prioritizing, of course, is where have we seen seepage? Where have we had a canal break? Where have we seen indications that we need this? But that deals in our prioritization. And as all of you have pointed out, that's an absolute immunity with regard to, once we decide to do that, we have an immunity with regard to it.
What's your response to Mr. Udall's argument that this really wasn't a program to protect the canals? It was just an experiment.
Well, I think if you look at, and if you'll pardon me for one moment, Your Honor, if you look at the separate statement of facts that was filed in response to the the separate statement of facts was filed in support of the motion for summary judgment. At paragraph 5, we specifically reference the fact that after analyzing the cost of each application, including installation and continuous maintenance, it was determined that shotcrete was the district's best option. And of course, this comes from Exhibit A to our statement of facts. So we actually address this exact argument in our statement of facts that supports the motion for summary judgment. We have two statements of facts directly behind one another. In an effort to control erosion of the district's canal banks, the board asked the district management to explore different possible erosion techniques and to select a few locations to experiment. And then the next statement of facts, after analyzing the cost of each application, including installation and continuous maintenance, it was determined that shotcrete was the district's best option. And so, we say, well, there we have it. We have it exactly from our Exhibit A. We address exactly that issue. And, I think it's interesting to note that, and we filed a motion to strike the reference to Mr. Clemens' testimony in the brief filed by plaintiff. If plaintiff wanted to argue that something else should have been done, that somehow that there should have been other steps taken that didn't involve our prioritization, they had an obligation to come forth with some kind of admissible evidence, evidence that you're supposed to be able to rely on, that's supposed to be admissible in court under Rule 56E of the Arizona Rules of Civil Procedure. You can't file an affidavit or from your expert 50 days after a motion for summary judgment has been granted and say, based on this affidavit, the court should have denied a motion for summary judgment. And references to the kinds of things that they refer to, brochures.
I understand your argument, counsel. I guess I'm just having trouble. What's the relevance of the affidavit of the expert in terms of the district's decision to implement this policy, to use its discretion, to allocate its resources, and exercise its fundamental governmental function in the profession?
The short answer is none, Your Honor. I mean, that's a separate, that's a separate issue they're trying to raise, but it has no application to Cole and the absolute immunity that's provided under the statute that's discussed in Cole. I mean, I think when you look at the, as you pointed out, you look at the matrix that was done in this case, it is almost a perfect following of Cole in terms of how the district is trying to approach the issue. They're looking at a problem. They're deciding that there's a gopher infestation problem. They're creating a matrix through their director to address this problem. The matrix specifically sets forth various topics under which the risk involved is addressed. They make a determination as to how much money they're going to apportion to address this issue, which is clearly a governmental function, and they carry it out pursuant to their matrix.
Now, I know that Judge Portley's question, we discussed it during conference, was why there was no third-party complaint filed against the Gophers. Is that right?
No. But even if the purpose of the matrix and the purpose of maintaining the canals, even if the Gophers were only a small part of that, would that make any difference?
No. I mean, the decision to address the gopher problem is done through this matrix. I mean, this is how the decision is made to address the gopher problem. Once again, if you look at the board minutes, the minutes of the board meeting, it specifically says we're addressing erosion and gophers. We attached that board meeting to Mr.
I don't know it's so clear from the board. I think, Mr. Udall is right in that, when you look at the underlying documents, I'm not saying it's not there. It's the place where it is clear is in Mr. Garrick's affidavit.
Right.
He states that. I don't see an affidavit that contradicts that. But, the minutes and so forth, they talk about erosion. I don't see it as clear as you're stating it right now.
I understand what you're saying, Your Honor, but when you look at...
Ergo, the need for a third-party complaint?
When you look at the affidavit, the supplemental affidavit from Ed Garrick,
Right.
he specifically references in it, in addition to saying,
I know it's in the affidavit. You're right in that
Okay.
regard. I'm saying the documents that are attached, the minutes from the board meetings and so forth, it really doesn't say anything about rodent infestation.
well, and if you don't mind, I'll just cite to you the
ahead.
specific portion of it.
Is it paragraph 5 of his affidavit?
It talks about, it is paragraph 3 of the supplemental affidavit of Ed Garrick, and it references the December 17th, 2007 board meeting, where it said, the remaining items were presented to the board for information. They included discussions on possible concrete panel construction for use in lining the canal or gopher walls. It's clear that they're considering the gopher infestation problem as part of what they're doing.
Well, it's in your lining matrix as well.
Right.
Gopher infestation is
And it's
one
part of the
factors.
lining matrix as well, right?
Right.
So we believe there's an absolute immunity. We don't believe that anything was addressed that takes it out of the absolute immunity in terms of the response. And we believe the rest of the arguments that were made are really irrelevant to the issue. But even if they would be relevant, there was no evidence that what we did was negligent anyway. I mean, there's no evidence that presented that would be admissible at the time of a summary judgment motion. Even if somehow Cole wasn't applicable, which we certainly believe it is, no evidence whatsoever that is admissible that the way in which we supplemented our site creating program by looking for seepage, by hand digging out holes, by going over them with tires, by digging them out with backhoes. no admissible evidence whatsoever, even on those issues anyway, presented at the time of the summary judgment motion. But I believe all that's an irrelevant argument, in any event, because with the absolute immunity from Cole, it protects us from the liability in this case. And the argument that was made that we did not in any size, shape, or form, address anything other than Cole really isn't correct. If you look at our initial motion for summary judgment at page 6, we specifically say not only that there's absolute immunity under Cole, but that plaintiff has not submitted any evidence showing that we were negligent in any other way as well. Plaintiff clearly addresses these issues or tries to address these issues in his response. We address these issues in our reply. On every facet of this case, I believe we prevail. We prevail on Cole and the absolute immunity, and I really don't have to reach anything else. But even if the court were inclined to reach something else, there's no admissible evidence presented at the time of the summary judgment motion which would show that we acted negligently or unreasonably under the circumstances in any event. So it's really a two-pronged argument, if you would. One, I think Cole, which takes out everything from the, I think Cole just is the answer in period. Cole and the statute are just the answer in their entirety, if you would. But
Cole, as I understand your argument, Cole is the answer in the absence of any evidence that the district was grossly negligent in its implementation. Because when you raise the issue of a backhoe, I'm thinking, well, you could really upset the lining of a canal, but that's not an issue.
Yes, and when you talk about implementation of Cole, what you would really be talking about if there was a problem, just like in a if the city had put in a traffic light and done it negligently, well, that's not Cole. I mean, that's not, a failure to follow their program. That's not a governmental function of how much money are we going to apply. If you put in a traffic light and the signals don't work, that's an implementation problem. There's no argument in this case that the shotcreting that was done negligently. There's no argument that somehow the shotcreting that was done was ineffective or badly put in. And there's no evidence that, the program was bad. But even if there was, as Judge Gould pointed out and Judge Thompson pointed out, the issue, the Court of Appeals doesn't get to second guess how it is that we implement, well, not to implement, but how we decide this program. We have a matrix. We prioritize them. We filled in the stuff that there was enough money to fill in. In fact, we had a little money left over in this program, as Mr. Garrick pointed out, and we actually did an extra section that we hadn't anticipated doing initially because we used all of the funds that were appropriated by the legislature for this purpose. This is not a failure in implementation of the program. There's no argument of that. That, in fact, is not even addressed, really. If there are no further questions, I don't really have anything further to argue.
All right, thank you,
Thank you.
counsel.
I would agree with Mr. Herzog that the implementation of the program is not the issue. It's whether this fact pattern comes under Cole. Now, again, I emphasize the point that it was a test, and I'm going to refer to the district's 2009 newsletter. It's in the record on appeal, Exhibit 20. I'm sorry, this is the plaintiff's or the appellant's number 21, Exhibit A. And this is coming from the district's 2009 newsletter. It states, while the canal has hermetically sealed through years of decomposed organic compound, the canal continues to widen in spots because of erosion. No reference to gopher problems. While we have had success rebuilding our O&M road last year by reshaping the canal, the threat of erosion still exists. Therefore, the board approved the execution of a few test sections to commit erosion. This is not Cole. This is not a program that's going to continue. It is simply, let's just do this. This is where we got some problems. They don't say anywhere they're going to line the whole canal. Now, here's what I believe should have been done to bring this under Cole. They should have had an expert who would have who would have stated in an affidavit, we've got a problem with gophers. We can't solve it doing A, B, C, and X, Y, Z. There's only one way to do it. We do it with shotcreting. we have a scarcity of resources to do it, so we're going to do a matrix. We're going to look at where we seem to have the biggest infestation, and that's how we're going to go about it. That's what should have happened. At that point, then we have some problems. The plaintiffs have problems, and we have to use affidavits. But that was not done. This was not a program that comes under Cole. I respectfully submit that the court erred, the trial court erred in its decision, and we would request that the court remand this matter to the trial court for further proceedings so we could have a trial. Thanks very much.
Thank you, counsel. We'll take this matter under advisement. We'll issue a written decision in due course. Court's in recess.